Hi, everyone. Welcome to episode 174 of the Immigration Lawyers Podcast. Today, we have a great guest doing some wonderful things for the immigration field. Jeff Joseph, our colleague in Colorado, partner at Joseph and Hall PC, with great partners who are doing a lot of great work as well. They have great Twitter feeds that I follow. But before we start, I want to remind everybody that the first issue of the Immigration Lawyers Immigration Lawyers Magazine, so used to saying the podcast, the magazine was released. And you could catch that at immigrationlawyerstoolbox.com/magazine, or just go to immigrationlawyerstoolbox.com and there's a link for the magazine. Chock full of information that's going to really help your practice. So please check that out. It's going to be a great thing in the field, I think. And already the feedback has been great. Along with that, I want to thank you to the various sponsors who helped make it possible. ME Translate, Immigration Finder, Journey, and DocuWise in particular has been so supportive of the podcast, the magazine. DocuWise, obviously, many of you know, is the form software and much more practice management software for immigration attorneys. If you want to get 10% off the annual plan, just go to www.docwise.com/immigration-lawyers-podcast and use the code Immigration Lawyers Podcast. You get 10% off, an additional 10% off the annual plan. So with this, I want to transfer and bring Jeff on. Jeff was kind enough to be on the cover with his two colleagues, Greg Siskin and Charles Cook. So they are doing some great litigation that really affected my clients deeply. These fiancés who were just on the phone crying with me every day. And then I found out about their class actions. Or Jeff, are they class actions, or are they labeled something differently, mass litigation?
Yeah, I mean, some of them are class action, some of them are mass litigation. Let me start by saying, first of all, thanks, John, for the invitation. You're doing pretty amazing things, getting the word out and really advancing the practice of immigration law. So great job on the first edition of your journal. It's really great work. So thanks a lot.
That. Yeah.
But anyways, with regard to litigation, some of it is class action, some of it is mass action. And a lot of times that's a strategic decision because the government is really loath right now, and the courts are really loath to sort of enforce injunctions on a mass scale, on a class-wide scale. Mm-hmm. So oftentimes, if we know we're going to go for injunctive relief, we sometimes shy away from making it a class action to avoid that sort of litigation piece. So the Milligan case is a good example of where we specifically chose not to file it as a class action.
And Milligan was so interesting because that's the case where these K-1 fiancés are not subject to travel bans. They're not moving forward. There's two parts. So one is the countries are moving forward. Then there's some people from those specific countries, China, Iran, and stuff. And you were able to get relief, but it was limited to the people that are plaintiffs. Can you still add plaintiffs to that? Because I have people contact me still every day trying to get in on it. Is it still open to being added to that?
Funny you should ask. Today, we're adding an additional approximately 393 plaintiffs to the Milligan case. We're going to file a motion to add additional plaintiffs. Stand by, because essentially the government has taken the position in the Milligan case that unless you're a named plaintiff in the lawsuit, you are not covered. K-1s are essentially shut off. You cannot get a K-1 fiancé visa. So in response to that, based on, we sort of were in pause to wait to see what the Biden administration would do. But given the fact that there does not seem to be any movement on the K-1 issue, our plan is to file another motion with the court to clarify whether that injunction only applies to named plaintiffs or across the board to any K-1 that's subject to the travel ban. It's our position that if you declare a proclamation unlawful, it's not unlawful only a particular people, and it's unlawful in general. And so it's sort of obvious to us, but the government, the Department of State, is taking the opposite position. So next week we will be filing a motion, and if that is granted, what it means is that all K-1s who are from proclamation countries subject to travel bans would be covered, and the consulates would have to start processing their visas.
That's amazing. And two notes on that. One is, practically speaking, I always tell clients, try to avoid the K-1 if you can, because a spouse of a U.S. citizen is so much better. You kind of avoid this stuff, which not inevitably happens. And surprising that the administration is still pursuing it. But on the other end, the result was really interesting. 212F was one of the primary powers of the president to stop people from coming. From what I read, the interpretation is it prevents them from allowing them into the country, but it doesn't mean they can't issue a visa, which is incredible, because all the travel bans get affected if that logic stands.
Right. I mean, that's absolutely true. I don't know of any court that has held that 212F can be interpreted in a way to shut down visa processing all around the country. All the courts that have considered this, in the 5 cases that have challenged it based on 212F, have agreed with us that 212F is narrowly prescribed to basically to allow the president authority to limit entry, but not to limit issuance of visas. And that's how it's been interpreted universally.
So hopefully it could just mainstay and the agencies continue working on this, even though, they're partially shut down and stuff. But yeah, all my cases who are part of the lawsuit, they're moving forward and they're scheduling. So one of these couples are like literally crying on the phone with I can't. One is before they knew they could do it, once they found out, tears of joy that they could finally reunite with their spouses. So God bless you on that work. Now, what about the other lawsuits issue? Because those affect H-1Bs and stuff. Did you go into those?
Yeah, sure. So we're also challenging the immigrant visa bans altogether in a case called Annunciado. And so that case is pending in California. The case has been briefed on the injunction, and we're just waiting literally momentarily for the judge to issue a decision on the injunction in that case. What that case seeks to do is find that the proclamations that ban the issuance of immigrant visas are unlawful across the board. And so this would apply to employment-based visas, family-based visas, diversity visas, all types of immigrant visas. If we win this one, it essentially means that the Department of State has to start processing immigrant visas again.
Wow, that's incredible.
And then we have another case in California called Tate v. Pompeo, Blinken now, Tate v. Blinken, which deals with the ban as it applies to O1 extraordinary ability visas. And then we have an additional case that's filed based on a wage rule that challenged that the Department of Labor essentially changed the methodology for determining wages for H-1Bs, E-3s, and PERMs. And we filed an injunction in that case. The injunction was interpreted as a motion for summary judgment, and we actually won summary judgment on the rulemaking in that case. And the Department of Labor was basically ordered to reissue 13,000 wages that had been issued between October 8th and December 4th when the rule was enjoined. Department of Labor has since reissued the rule. And they relied on a Supreme Court case called Little Sisters of the Poor, which essentially says, even if your rule was messed up in the first place and you shouldn't have done it, if you can show that you took into account the comments that were made during the comment period, you can republish the rule without notice and comment. And that's essentially what Department of Labor is trying to do, is they're trying to republish the rule and say that they took into account the nearly 2,500 comments that were issued in the rule. And so today, just about 10 minutes ago, we filed an amended complaint challenging the new rule and challenging rulemaking under Little Sisters of the Poor. So that's a case called Purdue that's pending in DC. And so watch that one too.
Has there been a change in, ferocity or just the administration coming in and changing what the governance attorneys are doing in this, how tough they're fighting this, or is it been no change at all? Because I'd imagine some of these it would just drop. You're not part of the diversity visa lottery, still continuing Curtis Morrison's lawsuit. I'm surprised that we continue to fight that.
Yeah, and interestingly, on the diversity side, they're fighting it aggressively. Of all the litigation we're doing, they're really challenging the diversity visa cases. And I think the reason for that is the statute essentially says that you really cannot issue a diversity visa after the fiscal year ends September 30th, 2020. It's our position, and Judge Mehta agreed with us, that the Department of State could reserve those visas. And in fact, Judge Mehta ordered 9,700 visas from fiscal year 2020 to be reserved past the fiscal year for Department of State to issue those visas. Department of State is essentially saying, no, we cannot do that. And they're locking in.
There's history of them reserving these visas for diversity visas, smaller case numbers, but I remember there was other cases last year before they did that too.
Not only that, and it's our position is that you're not issuing new visas. I mean, most of these people were issued visas in 2020, and we're just asking that their visas be reissued. So it's not like they haven't been counted against the 2020 cap. So they're really locking in on that case in particular. In terms of reading the tea leaves for the future in the Biden administration, I mean, I think, regardless of which administration we're dealing with, there's an incentive for the Department of Justice to preserve executive power, to preserve the power of the president. So I don't anticipate that they're going to give up this 212F battle, right? Because that is a presidential power that needs to exist. As far as the other cases, to be honest with you, John, it's more that it's not so much that they're fighting them. It's just that they really don't know. They really don't know what the Biden administration intends to do with proclamations, right? And there's a lot of competing interests, to be fair, right? You're not just dealing with Department of State. You're dealing with the Center for Disease Control. You're dealing with Department of Homeland, a whole bunch of agencies that have to make these decisions about how we treat COVID bans and proclamations. So I think we're just sort of in holding pattern right now for either the courts to do something or for the Biden administration to finally make a determination of what they're going to do with all these proclamations.
There was some case I read today where the Ninth Circuit said they're going to wait 60 days to see what the Biden administration is going to do. I can't remember what case it was. Reading that last 24 hours, but yeah, it's kind of a wait and see holding pattern. But yeah, as you said, you got to fight it because it's just the nature of the state to want to hold on to power. So it goes into political science of anything, but they're going to keep doing this. But I'm glad you guys are here to hold them to their feet to the fire, especially when it's really arbitrary, the K-1 and the Department of Labor kind of stuff.
Yeah, I mean, to us, to treat spouses of U.S. citizens as top priority in terms of national interest exceptions and everything, and to treat fiancés as the lowest priority based on the fact that they haven't said the words "I do" is the very definition of arbitrary. And so, we're really confident in the success rate of the fiancé case, and that we're probably going to win that one.
And speaking of these, the low priority of certain relationship kind of cases, hopefully we'll get a lawsuit in for the I-751s taking 18, 24 months. It's just for no reason. We have cases that are like open to show. They have 3 kids together. It's taking 18 months. It should have taken 5 minutes to prove. So hopefully that's in the tea leaves. They had some sort of thing that they said, the report by the ombudsman said naturalization is a priority. So USCIS focusing on that. The I-751s are not. They don't. But having a pending I-751 past 18 months now means you got to get a green card stamp for work permit for travel. It's really disruptive. What if relationship end in between? It's a mess. We get separated, divorce when I-751's pending. We need to get things out of the way. So that's something I really would. And I know you guys get handful, but get a lawsuit on that going would be wonderful.
We'll take any and all ideas for keeping the government's feet to the fire in immigration. So
let's talk about how you come together to do a lawsuit like this. Because these are major kind of things. Even doing a quick mandamus claim could blow up and become a big kind of job. And what was the impetus? How did you guys connect to make a decision to do this group kind of stuff? When did that happen? And how did that all work out?
So the 3 of us have always collaborated. We're all members of a group called the Alliance of Business Immigration Lawyers, able.com. And so we've always collaborated in terms of strategy and planning on business related issues, practice management related issues. But we realized in the Trump administration that we needed to challenge things on a more massive scale, right? We could file individual cases all day long and the government would never change their policy. They would just, settle those cases, kick them out of court and move on. And the only way to really create substantive challenge in an administration that was not talking to us, there was no other way to get movement, was to really file some major mass actions. And for a solo or small practitioner to do that is a real big challenge. So we sort of got together and realized that, between Greg's Twitter connections, he can tweet something out and everybody's listening. So he can tweet out an idea for a lawsuit and get a lot of people that are willing to participate. And, our firm has sort of the sustainability in terms of we've done a lot of federal court. We know how to draft the complaints. We know how to deal with the court system. And Chuck is just, he's a force.
You've been on the show about the CNMI. Was it CNMI lawsuits or in the Pacific when there were issues? Guam. It was Guam or something like that. There was some lawsuit, 2Bs or something like that.
Yes.
Okay, so you've been doing these kind of impact lawsuits and all sorts of type with the government. So actually, sorry I have a mind that jumps around a lot. I wanted you to continue. Well, what happened with that lawsuit? Is it still pending, or what happened with that?
Great question. It is still pending. The government, it has been a real challenging lawsuit because the government, we've survived now 2 motions to dismiss in that case. And the only reason that the case has not gone to summary judgment is that we can't come to an agreement on discovery, because the government's position is that the discovery is limited to the administrative record. And our position is you changed the rules. You started a new interpretation of H-2B, which means the discovery is bigger than the administrative record. We want to depose people and find out when did things change. And Having survived the second motion to dismiss, I think the government's a little concerned now because we're now in talks about how we can resolve this discovery dispute.
Was it that case where the judge, magistrate judge, might have put penalties on it for not following their orders? Was that, am I thinking about a different case?
No, that's the case. We actually won a contempt motion against the government.
What were the consequences of the motion? Did they do anything at all? Or it's just like,
well, I mean, they appealed that motion. So when the way that federal court works is if a magistrate judge issues an order, they can appeal the order. Any party can appeal the order to the chief judge. So we won contempt before the magistrate, and then the chief judge overruled the contempt motion. So unfortunately, her position, you know, she took a very narrow interpretation of what the order was and said essentially that as long as the government can justify the change in temporary need on an individual case, they can continue to deny cases. So
we could have this leniency. There's a colleague of ours, Becky Moreo, in I think North Carolina or something, who was held in contempt and trying to disbar her for using her cell phone. And they're throwing the kitchen sink at her for something that's really minor. But I'm going to talk more about that future. So sorry, I cut you off. So Greg says we got a Twitter account. You guys have this, you know, litigation background that you do deep for many years. And Charles Cook also has both litigation background and, you know, a social media, basically, his own podcast as well. And so you guys coordinated and say, we're going to do this. How does that even work? It's basically practically like, you know, money coming in and like, you know, who calls who and who's the attorney on the case for clients to follow up. How do you manage all that with these kind of numbers?
Great question. So we've kind of split it up between the firms. So, you know, depending on the litigation. So for example, I'm in charge, I'm the lead counsel on the Milligan K1 fiance case. So the way that we split it up is our office has better capacity to do the financial piece of things. So our firm usually does the intake of the money, ACH transfers. One of the challenges was in the Milligan case, a lot of those people don't have access to banks or even credit cards. So it was really Western Union.
Wow.
One of the funny things that happened with this case is my wife went down to Western Union to pick up a transfer, the amount of money that was sitting in Western Union, and they were not used to doing that kind of money transfer. You know, they're used to giving out $100 or $200. And so we ended up having to go to Western Union headquarters to get them to clear the deposit to get us the money. So there is a lot of logistics that go into managing a case like this. We now have over 1,000 Milligan plaintiffs. So you can imagine the email correspondence that we get on those. So one of the things that makes this successful is automating processes, right? So Greg is really, really good at automating processes. So for example, we have an automated declaration creator so that clients can go in and type in their information and it produces the declaration that we need for the TRO or the injunction. Rather than have them email us individually, we have a spreadsheet where they can go in and update their status, and we can sort by date to see, you know, the latest updates. So a lot of making this management successful is by automating those processes and taking the human out of it that would require staffing.
The email, especially for a Milligan type case, when the clients write emails, 5 paragraphs of emotional information, but they don't include like the date of birth that they need or the date of this. And so having like that is mandatory. And Greg is so on top of all the technology and coding and that kind of stuff. He's always doing some neat stuff. He's on the team to help manage that. But another thing is like when, you know, you have a situation where you go to pick up the money and you can't go to the headquarters of that, you know, people don't understand when you're a lawyer, all this is massive amount of time that you have to put in for things that are not even legal, but it still sucks up your time and it's money. So you individually have to sign off, or partner has to sign off. And so it's really hard to judge how much to charge on these cases. It's really difficult when you do a flat rate, especially.
And it's really hard to do. I mean, you know, granted, a couple of our cases are pro bono, right? We just took them on pro bono. The Purdue case, we're doing pro bono. But when you're doing a case that is this massive, really the only possible way to do it is to spread out these massive costs amongst a lot of plaintiffs. I mean, You're right. It is very cost and time intensive to do this kind of work.
So, I mean, like the class action, like, you know, 30 cases, that's enough. And it kind of controls the situation better for you. But this strategy of doing class actions, doesn't work best right now with the direction the federal court has taken, as you said before?
Yeah, I mean, for example, in the Annunciado case, which is the immigrant visa ban, we are filing that as a class action. We decided strategically to file that one as a class action. Why? Because it wasn't just a particular group of people we're dealing with. It is a whole bunch of different issues. And we're essentially taking on the entire proclamation. So for that one, it made sense not to parse out different groups of people, but just to challenge it as a class action. Same thing in the Purdue case.
Is it possible the court come back and say, wait till March 31st to see what the president does, or are they still moving forward with it?
They have said that. They have, several courts have said, let's just give this some time before to see what happens with the proclamations. Even the courts that have not said that, that's our suspicion as to why they're not issuing injunctions, is they don't want to issue an injunction just to have a proclamation rescinded on March 31st. The problem with that, and we've been very aggressive with the courts about this, is that every single day that is delayed in an injunction means somebody loses their diversity visa. We have a ton of diversity visas that will simply go away in the month of March. So we don't have the luxury with our plaintiffs to wait till March 31st to determine what Biden wants to do.
And in some of these cases, a parent or holder, they might pass away, so the petition disappears. There might be jobs that are lost and decide not to go forward. So there's real repercussions for regular people. And eventually, the lawsuit's going to win or the proclamation goes away. How's the consular system going to handle this mass amount of backlog of cases? They already have a hard time delays. Oh my God, it's going to take forever to get done consular processing. We're going to get emails from clients. How come my appointment's not here? And that it's just a huge mess.
Well, we know from the discovery in the Gomez case that there are over 250,000 cases in the immigrant visa backlog alone at consulates. So you take the 250,000 cases that are just sitting there waiting, and then you add on all the cases that continue to be added each day. It's going to take years to get over this backlog. And so even though the litigation is finished on, whether this is legal, what the Department of State is doing, the whole next phase of this is the mandamus litigation that's going to happen for cases that are just being delayed for 2 and 3 years. That's the next phase of litigation, and that's going to be happening during the Biden administration.
Here's another lawsuit. Because of the lack of consular cases, all of a sudden, adjustment of status for EB2, EB3 opened up in October. I'm sure you're from all the firms to business, got hit really hard with mass amounts of cases they had to submit, which was a crazy time. But then now it's taking 3 months to get receipts on cases. And if there was a glitch on a case was rejected, then you're delayed 3 months. You might have missed a visa bulletin window. That's another lawsuit right there. It's like, I understand COVID creates problems in the mailroom that you can't have 6 feet distance. You can't fit all these people, but you can't take 3-4 months to get receipts. You can't take 8 to 10 months to send biometrics notices. I have a reentry permit right now. It's been 8 months and no biometrics notice. And they're like, going on here.
And then you couple that with the fact that cases are getting rejected for not checking a particular box or not putting NA in a space, right? So you wait 6 months to see if your case is even accepted. And then you get a nonsense rejection for a non-material factor. I mean, it's just, these are things that we're paying for. These are things that our clients pay for. This is not a discretionary benefit. This is something, an adjudication is something we're entitled to, having paid for it. And so the fact that the government is taking 6 months to even issue an acknowledgement of what we've paid for is ludicrous. It needs to be challenged.
It's such a mess. And, I get some cases we file it now and we get the receipts like in 3 weeks, and still other ones are pending for months and months. And it's kind of somewhat better, but not really. And the visa bulletin jumping around with retrogression for some categories. A lot of people got hit, and some lawyers maybe malpractice because they didn't, on the I-485, they didn't mark a certain box if they're doing a U visa request or something. There's some 3 boxes that are kind of hidden.
Yeah.
It's just the form itself is gone so arbitrary, 20 pages. I remember when I started, it was like 4, I think, and probably earlier when you started, it was probably 2 pages. Now I want 30 to be 2 pages. It's how big it's gone.
Yeah, one of the good pieces of litigation out there is a case called Vagala, which is a case filed by AIC and a couple of other organizations challenging this blank space policy. Rejecting cases for not putting NA in the blank space. And I know that there's some advocacy going on right now to try and expand Vagala to beyond asylum to other types of cases, and to get USCIS to take a position that they will not reject cases based on these, failure to put NA or checking a wrong box.
Or at the very least, when they do this stuff, give us notice you're going to start doing it. They'll just like put on a website hidden in some part, maybe before filing. And also, they'll change the mailing address the day before, like without notifying people, or change filing fees without notifying. There's like all this stuff that a lot of it was the previous administration, just tricks to try to throw people hurdles so they can mess up. And that was the modus operandi for that MO.
Yeah.
Yeah, we had Stephen Miller on some show to Fox show headlines, and he was just blasting the new immigration bill. Have you got a chance to skim through it? It's like 335 pages, but
I have. The way I described it to my staff today, it was like I felt like I was in Willy Wonka's chocolate factory. Like everything was magical and wonderful in the bill. You know, it's like so many places to get good stuff. It is actually a very solid, good bill. Now, it doesn't have a lot of the employment stuff that I would have liked to have seen in a comprehensive bill. It's definitely more geared towards family and due process, but as far as that side of the practice, it is a really solid bill.
Yeah. Well, I mean, we'll see what happens. The Senate and House bill is still pretty evenly divided right now. It's hard to get it in. I imagine eventually it's going to be piecemeal, maybe help some TPS people, some DACA. But yes, see, hopefully something happens, because it doesn't make sense to have 11 million people, whatever the number is, in a country without status. Just if you don't have immigration, you just got to figure this stuff out. You got to be practical about life and help people adjust. And they're already working and paying taxes, either in sales taxes or some sort of employment taxes. Everyone's getting taxed. The U.S. makes sure they get their cut whenever something happens. So it's not like they're going to get all these benefits, which is a main argument might be people say, oh no, they're going to start getting taxpayer benefits. So, like, they're already here. If they're going to get taxpayer benefits, they're getting it. But most likely they're paying a bunch of taxes, but not getting Social Security benefits and on backside. So actually a net loss for them, net gain for the U.S. that they're illegal. And that's one of the reasons the business community is well known. You know, they save money in certain ways, or they play loopholes. It benefits certain employees, especially large corporations who are taking advantage of this labor source. So it's not. It helps a small group, really. It doesn't help the whole country by having to remain in this unknown status.
Yeah, for sure. I totally agree with you.
So how does the last question? It's a big question. What are your plans for 2021 with the firm, and which direction are you guys going?
Well, I mean, you know, it's interesting because the litigation piece of it really did sort of sustain us in a time where immigration practices were really struggling. You know, our corporate practice was not nearly what it should have been with COVID-19, but
I hope not.
and COVID 2020 and 2021 seems like it's just continuing and continuing. But the litigation practice sustained us. So, you know, we're putting a lot of energy into continuing to grow litigation, looking for opportunities to partner with other law firms, with people to do high impact litigation. So that's where we're definitely headed in 2021. The other side of this is just to keep our eye on the ball as with regard to the changes that are happening on a daily basis. It seems like, you know, just like under the Trump administration, it was announcements every day. We're getting the same thing from the Biden administration. So it's going to be really important for immigration practitioners to every day watch the news and make sure that they're on top of what's happening. So
for sure. If people want to reach out and talk with you or connect with you, is there a best way? Any social media handles that you have that you like people communicate with you or follow up with you on?
Yeah, so I'm probably most active on Twitter. You know, as things are happening, I'm also on AILA executive committee, so I tend to get access to information pretty quickly. So I try to put it out there as much as possible as a benefit to members and the public. So Twitter is probably the best way to follow me. But anyone can always email me at jeff@immigrationissues.com.
And your Twitter handle is just Jeff Joseph.
It is, yeah.
Wonderful. Well, Jeff, thanks so much for coming. I really appreciate it. Stick on the line. We'll talk for I want to thank everyone for coming and check out the magazine, Immigration Lawyers Toolbox magazine, out now with Jeff and our colleagues on the cover. All right, bye, everyone.
Keep up the good work, John.
Thank you.